California is the world's fifth largest economy and is considered one of the most influential and active U.S. states in regard to privacy legislation. In addition to its constitution, which provides individuals with a right to pursue and obtain privacy, California was the first state to adopt a breach notification law and has several sector-specific privacy laws, regulating health, finance, identity theft, online activities, and unsolicited commercial communications. This sectoral approach to privacy has, though recently, been consolidated through the Comprehensive California Consumer Privacy Act, commonly known as the CCPA, which took effect on January 1, 2020, following its enactment in 2018. The CCPA introduced new obligations for organizations that collect consumers' personal information, as well as establishing new rights for those individuals. Since it took effect, the CCPA has been amended a few times, including in September 2020, when bills exempting employee data and de-identified health information were signed into law by the California governor. In August 2020, and after various drafts and public consultations, the California Attorney General issued the final version of the CCPA regulations, as required under the CCPA statute. The regulations became effective on the date of their publication and clarify requirements and procedures under the CCPA, such as privacy notice obligations, responding to customer requests, account verification, and rules regarding children. On July 1, 2020, the Californian AG began enforcing the CCPA, with businesses having 30 days to cure any alleged violations under the statute. Penalties under the CCPA may result in fines of up to $7,500 per intentional violation and $2,500 per non-intentional violation. However, the results of any enforcement action taken by the AG have not been announced so far. The CCPA, however, is already set to be significantly amended by the California Privacy Rights Act of 2020, commonly known as the CPRA, which was passed in the California general election of November 3, 2020. The CPRA, introduced by Alastair Mactaggart, board chair and founder of the Californians for Consumer Privacy Group and proponent of the original CCPA, seeks to align more closely California's privacy legislation with the EU's General Data Protection Regulation, or GDPR. The CPRA will stipulate requirements for sensitive personal information, profiling, and automated decision-making, and establish the California Privacy Protection Agency, which would be a first-of-its-kind data privacy authority in the U.S., responsible for overseeing and enforcing the law and creating further regulations. The CPRA will enter into effect on January 1, 2023, but it will apply to personal information collected by a business on or after January 1, 2022, with the exception of the right of access. Although the CCPA provides the overarching legislative privacy framework in California, several additional laws still often need to be taken into consideration. In particular, the data breach law in California requires businesses that own or license computerized data that includes personal information to disclose a breach of the security of the system to any affected Californians, and, if data of more than 500 residents has been breached, to the AG. Other key privacy laws in the state include the California Online Privacy Protection Act, which requires from businesses to post their privacy policies on their websites, the Shine the Light Law, which addresses the practice of sharing personal information with third parties, and the California Invasion of Privacy Act, which grants to California individuals certain protections in their communications via telephones. To continue researching key compliance requirements in California, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.